Good morning, everyone. Welcome to our Wednesday Q&A. We're going to give a couple more seconds to get everyone in from the waiting room. And it looks like we're good to go. Thank you for joining us today. We are going to start with our usual Zoom housekeeping tips. Um, if you want to have your video on, you can do that. Your Zoom toolbar is typically at the bottom of your screen on whatever device you're using. The chat function is for asking for clarification or asking questions. We may have time for questions at the end. So if you want to ask a question, ask for clarification, please put that into the chat. We will be monitoring it. And just a reminder that the chat function and this Q&A is not legal advice. We're here to give general information that may be applicable to many different communities within our state, but we are not your attorney unless you have a signed fee agreement with our office. We cannot give legal advice in this forum. Anything we say here is general information. So if you have someone who sends you an email saying, well, condo law said this, or this video said X, that may not be applicable completely for your association because things differ depending on your governing documents and what statute that you're under. So please be mindful of that. Um, just kind of briefly, last year there was a lot of confusion regarding the Corporate Transparency Act, or the CTA. The Treasury Department sent out a memo saying that they were not going to enforce that particular regulation. And the last we know is that they have not done nothing to update. So if you're worrying about registering with the CTA or CTA compliance, as far as we know, that's still on hold and moot, but that could change. We don't know. Um, and then the last quick thing is the legislative changes that came into effect January 1st of 2026. So all communities, common interest communities in Washington state are subject to the Ukiah meetings provisions, including the requirement to hold open board meetings with notice to the owners and limitations on making substantive board decisions outside of open meetings. Also, there are new delinquency requirements, the delinquency notice requirements, limits on late fees, interest, and collection options, generally until the delinquency notices required by statute are sent. So if you have any questions or concerns regarding those particular issues, we dealt with them a lot in the last quarter of last year. So if you go onto our our YouTube channel and look through the past, I want to say 3 to 4 months of Q&As, you will find many discussions on these topics. Ken, did you have anything to add to that?
Nope, I'm good.
Okay, moving on to our first question. When the board conducts an action by unit owner voting by ballot and the board gives the outcome, what is the obligation of the board to certify the validity of the vote? And what is the procedure for validating the vote for declaration amendments, bylaws, election of board members, CPA audit vote, etc.? So there are too many variables for us to give one definitive answer. So the statute that you're going to be looking at is 6490-455. And most of this language has been adopted in the other statutes. So if you're not under 6490, just Google RCW, whatever statute you're under, and voting, and that will bring up your particular statute's voting requirements. So all the statute requires is that reasonable measures are taken to verify that each ballot, and this is paper ballot or person voting, anyone voting in person, are verified to be an owner within the community. So only owners are allowed to vote unless that owner has given the authority to someone else, basically a proxy, to vote in their place. So this is a new statute. There's no case law interpreting what reasonable measures to verify means. So you can double check the name on the ballot matches the owner information. If you're doing absentee ballots or there's a proxy, you can verify with the owner that they signed the proxy or sent a particular ballot. So for non-Ukiah communities, after January 1st, 2028, voting for board elections, removing someone from the board, or amendments to the declaration and bylaws must be done by secret ballot. So it also prohibits those on the ballot from counting the votes. That is applicable to Ukiah communities now. So how you do secret ballots, how those ballots are counted, as long as you are reasonable in how you're doing things, it's probable that a court would not uphold a challenge. So what's reasonable will vary depending on what the vote is about and how close the results are. If there are a few questionable votes, would they make a difference in the outcome? If the answer is yes, or it's a very close, highly contested issue, you need to be more careful and more precise in how you verify. If there's a couple questionable ballots, but everyone else voted a certain way, then you really don't need to worry about it too much. So, what is reasonable for paper ballots, electronic votes, or in-person voting at the meetings may all be different. So, by statute, there are several different ways that votes can be taken, and how those votes are cast and counted can be different. But in general, as long as you're being transparent and reasonable, generally you're going to be okay. So the last part of this question is, if the board is questioned by unit owners, how do we convey the validity of the ballot votes on anything? If they question the validity, do they have the right to view the actual ballots with the names and addresses on each ballot? So going back to statute, 6490-495 subsections O, ballots, proxies, absentee ballots, and other records relating to voting by unit owners must be maintained for 1 year after the election, action, or vote to which they relate. And ballots are a record of the association and are disclosable to owners. However, 6490-495 sub 3 sub H could allow the association to redact names and unit lots and numbers from ballots, but this has not been tested in court. So ballots are a record of the association. They are disclosable to owners. Whether or not you can redact the information on those ballots hasn't been tested. It's possible. Again, as long as they're reasonable, it's unlikely that a court would uphold a challenge. So having an independent nomination committee or trusted owners or managers doing the vote counting may satisfy owners that the vote results are legitimate. Sometimes attorneys or parliamentarians counting the votes, hiring someone to come to the meeting and just sit there and count the votes is done to satisfy conspiracy theorists. And we have done this for associations in the past where there was a particular group of owners or a particularly contentious issue, and they wanted to have an attorney present to count the votes and verify that the votes taken were counted properly. Again, there are too many variables to answer definitively how things should be done. There is no case law telling us how a court would interpret these particular statutes. So be reasonable, take your best guess, try to not be a test case, and when in doubt, ask your association attorney. If you don't have an attorney and you know that there's a contentious issue, it might be a good idea to get one. Ken, did you have anything to add?
Well, if you've got owners who are really questioning it, part of the answer might be to ask the owners what would satisfy them with regards to how the votes are done. And if you're doing voting by paper ballots, it's usually pretty easy to check that the names on the ballots match the owners. Most of the electronic voting systems are using the email addresses. So if there's an email address on file for a particular owner and that matches the email by which a ballot was submitted, that is considered a way of validating the particular vote. And we have had some very contentious votes in the past. We had one where every owner had to mail in two ballots, one to our law firm and one to the law firm of the group of, I'll say dissenting owners. And then the two law firms both independently counted and then compared notes to decide whether the results were the same. And it was a community of about 50 homes. And in fact, the votes did not come out the same because at least one owner sent different votes to the two law firms. But that vote didn't matter because the vote had swung so clearly the other direction that you could completely disregard the ones that someone was questioning and still know what the outcome was. So it is, if you've got an owner who's contesting it in advance, you can try and work out something in advance with them. If you can't do that, you still conduct the balloting, you count the votes, and the election results can be audited after the fact if they need to be, because you've retained the ballots.
And there's a follow-up question in the chat. If the ballots are secret, how would the owner's name be tracked to a ballot for a vote challenge? So this is a new statute. There is no case law saying how this should run, but we have had secret ballots conducted in the past where when the ballots went out, a certain color was used for percentage of interest. And then the owner just did the vote on the ballot and then sent it in an envelope that traced back to their units. There are ways to get this, do a vote, a secret ballot. It's just a lot more cumbersome and more technical.
Yeah, also,
So,
I think that the secret part is how the person voted, not necessarily that the person voted or verifying that the owner filled in the ballot. So uh, if you get into a position where you need to deal with those issues, I would recommend you have an attorney assist you. And frequently there is another attorney on behalf of the people questioning the ballot, and you can work out a process. And that is typically what we've done is we've come to an agreement on how to verify the results of a vote after the fact and then apply that process. But anyway, moving on to the next question. Please explain what occurs when an association goes into receivership. So my first comment is that receivership, which would be a person taking over control of the association instead of a board of directors, is an incredibly uncommon thing to have happen. I've seen it once for one of my client associations, and it was because a bank owned a majority of the units and had a receivership appointed to protect the bank's interest until the units could be sold. For the receivership to occur, every owner in the community is going to have to be sued because a court is the only person who can appoint a receiver. And you're looking at taking away rights that belong to the individual owners. So they have to be included in the lawsuit. So someone, whether it's one owner or a manager, is going to have to sue in order to have the court appoint a receiver. If you don't have a management company, the receiver is not going to be the management company. They would turn around and hire a management company in addition. So you're going to be paying the receiver at their rates, and then you're going to be paying the management company to do things. So in addition to the cost of filing the lawsuit, you're going to have to pay the additional fees, the receiver and manager. And the receivership is going to continue until the court orders that it be terminated. It's not something where you just get to decide it's done. You could all agree that the receivership should end because the board of directors is finally willing to serve, but you still have to go to court and have that receivership terminated. So it's an expensive process. It's a difficult and time-consuming process. And it's one where, I'll say, except for this one case, every community has been willing to find somebody to step up and serve on the board. You can reduce the time commitments of the owners on the board by hiring additional professionals, whether those are engineers, attorneys, accountants, or managers, to help prepare information so that the board's decisions can be made more easily. Anything you want to add, Jennifer?
No, I'm good. So our next question is 6490-525 in play now for non-Ukiah common interest communities? The answer is yes. This statute has applied to every common interest community in Washington state since 2018 when Ukiah was first adopted. So the statute that says when a particular provision is applicable to non-Ukiah communities is 6490-365 sub 1. Ken, did you have anything to add to that?
Yeah, that statute lists less than a dozen parts of Ukiah that apply to all communities. The reserve study section has applied to all communities since 2019. And then the sections which relate to meetings and emergency meetings took effect for all communities in January of this year. Next question is, what are the available options for a lone board member when the majority chooses to violate state law and/or association governing documents? So I'm interpreting this question to mean that a lone board member has a disagreement about a legal conclusion that the rest of the board has made. So my first caution would be that whether or not there actually is a violation of law or a violation of the governing documents is frequently an opinion, and it's going to be an opinion until a court has actually ruled on whether or not it's a violation. You can get a legal opinion that says it should be a violation, but even then there might be differing legal opinions on whether something is a violation. So we don't represent individual board members against their boards because that is effectively representing an individual owner, and we pretty much limit our practice to representing full associations or the boards. There are going to be a lot of variables which might affect different conclusions by different people on whether or not a violation occurred. So, for example, if the statute says you can only take ministerial acts by email, and one board member believes that the act is ministerial and another board member believes it's not ministerial, there's no way to really resolve that question absent a court order because the term ministerial is not defined in the statute. So if you have a disagreement with your board members and you believe it is truly a violation of law or the governing documents, your first thing we would normally recommend is, explain yourself, document or show in writing what the portions of the statute or portions of the governing documents you believe have been violated, and maybe they'll agree with you. You can always resign from the board of directors if you feel like they are doing something which is illegal and it might affect your liability or credibility. You can try and get different board members elected. You can try and educate all of the owners and ask the owners to try and recall the board members because they are not following the law or the declaration. But that's going to require that you have a sufficient number of owners both to call a meeting to remove board members, and then you need to have a much larger percentage in order to remove board members. Typically, to remove board members is going to require either 67% of those attending a meeting with a quorum or a majority of all of the members of the community, whichever of those two numbers is smaller. And then the last option, of course, is you can sue the association because of the failure of the association to follow the law or follow the governing documents. And you can then let a court decide that there actually has been a violation, and the court would then also determine what the remedy would be. Anything you want to add, Jennifer?
No, I think you covered it. So our next question is, do you have any guidelines about long-term document storage? With our change to a new management company, we want to store current documents on the new website, but probably only for a limited number of years. Then have a rolling trove of documents so old ones roll off as new ones are created. I'm not sure what our long-term storage needs to look like, but would first like to know what we need to retain and for how long. So statute changed, I think it was back in 21 or maybe earlier, and all governing statutes in Washington state more closely follow the Ukiah statute. So 6490, 495 is the record statute for Ukiah. If you're not under 6490, just Google RCW, whatever your governing statute is, and records, and it will pull up what your particular statute is for records. So the statute lists the categories of documents that are association records and how long they must be retained. So things like annual and board meeting minutes, copies of governing documents must be kept forever. Other documents have different retention periods from as short as a year for ballots and voting materials to 7 years for contracts or modification requests for individual units. So the burden is on the association to maintain the records. You can store documents digitally as long as you're able to open and view them whenever needed, and they can be printed. Some associations have used Google or OneDrive to maintain copies of records. Now, please note that many management companies have web portals for storage of documents so they can be viewed by owners and board members. And using a portal or whatever software your management company has makes sense. But also, we have seen instances where either records weren't completely transferred during a management change, or where documents have been lost. But the burden is on the association to maintain copies of these documents. So having a backup is, or maintain the association yourself, maintaining a repository is probably the best practice to have. Um, when a document is no longer needed or required to be maintained, get rid of it. So you don't have these 10, 20, 30 banker boxes of records that have to be gone through every time the board changed or a management changed. There are companies that will scan the documents for you. There are ways to reduce the paper that has to be transferred or get rid of the paper entirely, but make sure that your association has a repository or a separate backup. So you are able to pull the records that you're required to maintain. Ken, did you have anything to add to that?
Yeah, probably you'd have to have two, uh, I'll say two record storage systems or files. One is going to be those records that would be available to everybody because they're records of the association and there is no obligation to redact information. So all your governing documents, board meeting minutes, things like that would fall into that category. Probably contracts, invoices, financial records would also fall into that. But then there's the records where the statute requires the association to redact information. So the information on how people voted, we were talking about earlier, is supposed to be redacted. So you can't just copy those documents freely onto a website and allow owners to review them because you have to redact information. And there's a laundry list in the statute of information that has to be redacted. So you don't make information about other units available to every unit owner who requests it. They're allowed all the records for their own unit, but not every other unit. And so you're going to have some specific management protocols in order to save the documents electronically. This would be true whether you're saving them paper form also, because you can't just pull a box out of storage and hand it to an owner who wants to look at it if you are required to redact information from that box. So we have seen clients who have taken the statute and looked at the amount of time they're supposed to save records and gone through all of their records and thrown away boxes and boxes of documents. We had one client that was using our copy machine to scan documents because our machine would scan both sides of every page at the same time, and it was very fast. Put it on an electronic flash drive for them. They came in with 32 banker boxes, and I think the board president probably spent 8 or 9 hours going through scanning documents. She'd pull them out, decide if they were over 7 years old or not. If they were over 7 years old and were not a permanent record, they just went straight into the shredding bin. And then she would scan the others. But that was a real significant investment of time on her part because then she took the flash drive and had to rename every file and store it into their, OneDrive or whatever they were using. Uh, but theoretically, it has eliminated all of the paper documents for that particular community, and they can keep a record independent of their management company of that storage file set, so that if they change management companies or the management company's computer were to fail, they would still have all the records that they needed. So it's certainly, another one of those many things that boards and managers could be thinking about how to do better. Um, but that doesn't mean there's an urgency to trying to resolve that problem. Um, Next question. Can you discuss reverse mortgages and homeowner associations? What are impacts to associations who might wish to qualify? So a reverse mortgage is when an owner, usually an elderly owner, takes out a mortgage that allows for money to be paid on a monthly basis to the owner rather than them paying to the bank. It basically assumes there's a lot of equity in the home to start out, and the person is using that equity to pay their expenses. And the reverse mortgages are only offered through FHA, so you have to be FHA eligible. There are a few requirements for associations to be FHA eligible, which include, reasonable restrictions or no restrictions on rentals. You can't require residency prior to renting. You can't have lease approval by the board. There's not a lot, but does require that you be FHA eligible. And these are really a transaction between the owner and the bank. They're not something the HOA is otherwise involved in. The only other thing we could think of that might be impacting an association is that the association has lien rights against a unit, and so does the bank. And the statute set up a priority of whose lien right comes first. So if someone gets a reverse mortgage and then they were to die or sell, the bank is going to be paid off first, except to the extent the statutes otherwise provide. Ukiah provides a 6-month priority for the association's regular assessments. So if you have someone with a reverse mortgage, you might want to be concerned about making sure that you are protecting any lien rights you have for a delinquent owner. If they become delinquent more than 6 months, you would risk losing more than that to a bank if there's a foreclosure. Anything you want to add, Jennifer?
I don't think so. Moving on to the next question. So under RCW 6438, the board must send the ratified budget to homeowners within 30 days of its adoption. Does the 30 days exclude Sundays and holidays? Probably not. There's no case law on this to say definitively one way or another. The actual statute is 6490-525. This language on budgets and budget ratification has been adopted in the other statutes as well, but this is where it originally came from, is 6490-525. So the notice of the meeting to ratify the budget and the approved budget must be sent to owners for the owners to view within 30 days of the board's adoption of the proposed budget. So were a board to miss the 30-day deadline, they could always just adopt the budget again and then send out the notice within the 30-day time frame. The risk is low regarding the time between adoption and the notice going out. The risk of a challenge and a court finding that the board acted improperly is much higher regarding time between the notice going out and the date of the ratification meeting. So the statute sets two separate dates. The 30-day time frame is for the board to send out the approved budget and the notice of meeting. So once that is sent out, you have, is it 50 days to
14 to 50 days.
14 to 50 days to hold the actual meeting. So you are not required to adopt the budget. A board isn't required to adopt the budget, send out the notice of meeting, and then hold the meeting within 30 days. You are required to send out the notice and the notice of the meeting and the budget within 30 days. But the meeting has to happen within no less than 14 days after the notice is sent or more than 50 days after the notice is sent. So there's two separate things there. And I think I'm repeating myself. Ken, did you have anything to add?
I just, I don't know how a owner could prove any damages or injury if the board were to send a notice out, 40 days after instead of 30, as long as they provided the required 14 to 50 days before the budget is ratified. But, I guess it really depends on how much of a stickler one is to the rules. Next question is regarding a delinquency letter. I guess that there was a specific letter sent in which we are not reviewing. And it's about whether or not fines can be considered when a foreclosure is being considered by the board. So we would recommend you look at the statute, which is for Ukiah, section 485. And there are some new changes about how you have to give notice of a delinquency to an owner. You're required to now send a pre-foreclosure notice out within 30 days after an assessment comes past due. And that's past due is the date it's due. So if the assessment is due on the first of the month, you're supposed to send a notice out within 30 days of the first of the month. You don't wait the 10 days before you would assign a late fee and then count 30 days. You don't wait 30 days if you give a 30-day grace period and then start counting the 30 days. The statute's pretty clear, and there are limits on how much you can charge for late fees and management fees until that pre-foreclosure notice has been sent. So there are significant differences for every community between how you could deal with collections last year and how you have to deal with them going forward, starting this year. And a lot of communities are not going to care about the inability to assess, the late fees or the management fees that may be involved. A lot of clients are going to be very concerned about that because there's a limit on how much you can assess as late fees, which, if I recall correctly, is the lesser of 5% of the delinquent amount or $50. And you cannot assess a management or administrative fee larger than $10 with that first delinquency notice. And if you haven't sent the pre-foreclosure notice, you can't assess any other late fees or um, or administrative fees. So it's becoming important to follow this step of mailing out the pre-foreclosure notice within 30 days. That's starting to shorten up timelines because if you're not usually looking at delinquencies until 15 days into the month, you have only 15 days to get the notice out in the mail to those owners that did not pay on the first of the month. And this is, again, another one of those things where someone had a legislative purpose of making sure that owners were well informed about the risks of their not paying their dues, and they imposed additional requirements and restrictions on the associations without thinking about how it was going to impact those associations. And it's making the uh, the documentation required for collections more difficult. So I'm not sure if that actually answered the question. If we get back to just the question of can you do a foreclosure for fines, the answer is no, because the statute specifically says that you cannot use foreclosure to collect fines. You can only pursue a foreclosure if the unpaid assessments, exclusive of attorney's fees, exclusive of late fees, exclusive of interest, and exclusive of fines, totals at least $2,000. And we do recognize that there are some homeowner associations where their regular annual dues are so small that they may never reach the threshold at which they could pursue a foreclosure for a delinquent owner. And so that does start to limit your ability to collect from those owners. Doesn't mean you can't pursue other methods, like a personal lawsuit, but you couldn't foreclose on their home. So I probably wandered way off track on that, but do you have anything you want to add, Jennifer?
Just briefly, I put the statute in the chat for 6490-485. Um, Again, this language is applicable to everyone. It started January 1st of 26. So the statute says no later than 30 days after an assessment becomes past due. So no later means it must happen within that 30 days. And there was a follow-up question, can you send the notice on the 15th or do you have to wait until the 30-day mark? You can send it, frankly, this on the 2nd. We wouldn't necessarily recommend that, but before any, once any assessment, including fines, is past due, you are required to send the pre-foreclosure notice of delinquency, even though that you may never get to a foreclosure. Statute requires that this notice be sent, and you're stuck with it. Did you
Yeah,
want to
I
add
would say
anything?
if you're sending a, just a, hey, we missed your payment reminder to someone at 10 or 15 days. Just include the pre-foreclosure notice that's required by statute.
And there's a second follow-up chat. We're going to kind of curtail this because we covered this extensively in the last 3, 4 months last year. So if you go back to our YouTube channel and search for notice of delinquency or foreclosure or statutory changes, you'll find a wealth of information there because we covered this a lot. So is a late notice considered an assessment and would require a new notice of okay, and require a new notice of delinquency? No. An assessment is money that an owner owes to the association. So fines, fees, your regular dues, the actual term for those are assessments. So dues is shorthand. I know a lot of people use it. The formal term is assessment. So if you have a regular late notice that you send people, as Ken said, just add the required language, notice of delinquency, and then you're fine.
Well, also make sure that if you're going to charge a late fee, that at least the first late fee complies with the dollar amount that's limited in the statute, which is 5% or $50, whichever is smaller.
And Chelsea just reminded me, we did do a one-page flyer regarding this issue. If you want a copy of that, please email info@condolaw.net asking for a copy of the collections changes flyer, and she will get that out to you. So moving on to our next question, and this is going to be a longer one. The new law states that all board meetings must be open. I'm a little confused about what this means. Plus, there's added law of nothing can be discussed on email except administrative functions. Examples. Can we meet to set the agenda or does that need to be open? So I'm going to handle this in different parts just because there's a lot of different subparts to this question. But we covered this a lot in the last 3, 4 months of last year. Please double check the YouTube channel for those. We also did a short handout on changes regarding open meetings. So email info@condolaw.net. Chelsea will get that out to you. But answering these particular questions, we don't know how a court would consider compliance with what is pretty strict language in the statute. The minimum is that we encourage substantial compliance and good faith to meet the intent of the statute. If your board meetings must be open to view to all owners, and owners are required to have notice of your meetings. So as long as you're acting in good faith and doing your best to handle all discussions in an open forum, except for those that can be done in executive session, you're probably going to be okay. But specifically, the board president generally sets the agenda with the management company if there is a management company. If a board member has a topic for the agenda, they can just send an email off to the board president saying, hey, can we add this topic to the agenda? Discussing discussing the actual topic should not happen over email. Asking for it to be added to the agenda is probably okay. It's fairly low risk, especially if the meet or the main discussion regarding that topic happens in an open meeting. So the next example, can we meet to discuss setting the calendar for the year or does that need to be open? The answer is meetings to discuss the setting the calendar for board meetings should happen in an open session. So if you haven't done that already, consider adding that to your standing agenda for November or December of the prior year. It just, that's one of the things that it probably is not ministerial and should happen in an open forum. So, next question, can we meet to determine what inspections need to be done this year, or does that need to be open? That must happen in an open session. So, a next question, what exactly is administrative via email, and what would be an example of not administrative action via email? So the term in the statute is ministerial, not administrative. That particular term is not defined in the statute, but it generally means actions following established guidelines which do not require exercise of personal judgment. So if the board has already voted to accept a contract and outside of the meeting, the board president signs the contract, that's probably a ministerial action. It doesn't require uh, any other action on the part of the board or the board president. If we have associations who have developed policies for allowing management company or individual board members to take certain actions outside of a regular board meeting. With that authority, the manager or particular board member is not exercising their personal judgment because they've been authorized by the board to take that action. So that would not be ministerial. But again, there is no case law on this. As long as you're acting reasonably and trying to follow the parameters of the statute, you're probably going to be fine. Um, so the next question is, I've sent out many emails to the board with things that need to be considered and acted upon at the next board meeting. Is this allowed? Probably not. And the reason for that is that if those particular issues are not added to the agenda that goes out to the owners don't know what those particular topics are, so they wouldn't be able to give an opinion or speak to the board about it in the open session that's required to happen before the board takes any action. So take a look at our YouTube channel, ask for the handout. As long as you're handling things as openly as possible, you're probably not going to have a problem. Ken, did you have anything to add to that?
Well, yeah, this is a question which we are getting an enormous number of questions from managers and board members. And I wish there was a bright line rule that we could give you, and there's not. The legislative language is pretty plain and clear and unambiguous that you're supposed to be making all decisions in board meetings, except this quote ministerial exception they've provided. Then they didn't define ministerial. I think an example of ministerial might be if the board were to pass a motion to, cut down a tree at a cost not to exceed $2,000. Then you got bids. I think it would be ministerial for the board to approve hiring Bob's Landscaping to cut the tree down at a price of $1,500 because the board had already made a decision in an open meeting to cut the tree down for not more than $2,000. So I think that would be ministerial, but until the court rules, I can't know for sure. I think if you had a procedure in your rules and governing documents, so for example, that if you had a collections policy that said that at 60 days delinquent, you would send a delinquent owner to an attorney for collections, then I think at 60 days you could have an email that was approved by all the board members to send the delinquent owner to collections because it is following an established procedure or guideline. It is not something which is exercising judgment on the part of the board. But I do think that would still require that vote by email if it's not done in an open meeting. And so, and I also recognize there is a conflict, and I have a lot of people jumping on this. The section, it's section I of the statute, which says you have to do all decisions in open meetings. But then section L, 3 paragraphs later or so, says that any action of the board is going to be valid unless it's set aside by a court. And then it sets specific procedures for when the court can do that. And, I've got some clients who say, well, we'll just do everything however we want and then rely on this savings clause, as it were, to make sure everything is still valid. And part of my caution is that you're required to make some good faith effort to comply with the statutes. If you are intentionally avoiding the open meetings provisions, then I think that you're not going to be saved by that provision that says it's still valid. If you are accidentally doing it or you're acting in good faith, then I think the savings clause is going to work. But it is a challenge because you've got section 4452I and 4452L that seem to contradict each other. And I agree, they do contradict each other, and we just don't know what the legislature intended. Anything else, Jennifer?
There's a follow-up comment in the chat. Boards are trying to get creative on expanding what is ministerial. How can we as managers keep them from wandering too far from the rule? So you can advise a board, but if the board decides to do something that is not, or you don't believe follows statute, you can advise them. They're going to do what they're going to do. And then the board themselves have the risk of the challenge from an owner. We believe that the statute is extremely clear that a very limited number of decisions can be made outside of an open forum. The legislative intent behind this statute is for everything to be as open to owners as possible. If you have a board conducting meetings and calling them
Working sessions. Yes.
yes, thank you. I need more caffeine. But calling things working sessions or having discussions outside of a board meeting and then just coming to the board meeting and doing votes. That's not within the legislative intent. It is open to challenge by an owner. And please remember, as board members, if someone challenges a board action and you acted outside of your statutory authority and duty as a board member, you can be personally liable for any sort of fees and costs from that lawsuit. And likely there will not be insurance defense counsel appointed because actions outside of a board's duty of care is not covered by D&O insurance. So this is not an area where people can just play loose and expect that a court will follow the business judgment rule and just say that what you did is fine.
Yeah. Now, we do have one client which has formally adopted a definition of what a ministerial act is. And what they did was actually research and used a definition that was supported by, I think, the Cornell Law School. And so that is a reasonable way of trying to help clarify for your community what acts can be done by a board. It's just that the definition of ministerial has to be one which would be supportable. And that's why they use the law school. But anyway, our last question today is, our condo association is considering sending owners who've not paid fines to a collections agency rather than sending them to an attorney. And this is, I think, because they can't use the attorney to foreclose on a fine. Is there any major downside in general for such an approach? So we could certainly have a long conversation about the differences between how collections agencies work and how attorneys work. Um, I consider there to be some significant downsides because we have watched collections agencies really abuse some of our clients. The appeal of collections agencies is you don't pay any money up front, you just send the delinquency to them. But if you read the contract which you are signing with the collections agency, you are basically giving them the discretion to pursue the collections or not. And they often are really reluctant to invest time because the amounts involved are too small for them. If you want to take it back from the collections agency, you are required to pay them the fee they would have gotten if they did collect, which makes it very difficult to get it back. You may not be able to recover any of the attorney's fees they want to expend because they are not association expenses and therefore cannot be assessed to the owner. You're going to usually collect only a portion of the amount because the collections agency is going to take a percentage. But really, I guess what it comes down to is the contract with the collections agency is what is going to determine the major downsides of using a collections agency instead of an attorney. And it's going to sound silly for me to say this, but you should have that contract evaluated by an attorney to make sure you understand its terms and conditions before you agree to it. The same as we recommend for any construction contract or a contract of any other kind that the association is going to enter into. You're trying to make sure that your interests are protected, not the interests of the party who prepared the contract for you to sign. Anything you want to add, Jennifer?
No, I think you covered it. We have 3 minutes remaining, so we're going to go let go a little early. Thank you everyone for joining us. Have a great day.